shared plan. So if it's a shared plan, you can import it.
I'm Joe Cry from the Legislative Reference Bureau. I'm joined today by Mike Gallagher. We are both legislative drafting attorneys. Stacy Duros is not able to be with us this afternoon, so I will take her place and try to do her well. I'm going to start out with covering just kind of the basic redistricting law and principles, and then Mike's going to get to the nuts and bolts of really why we're all here, and that's the local redistricting procedures. I'm going to start out talking briefly about the LRB before I get into the basic redistricting law and principles and before Mike gets to the local redistricting. The LRB is a nonpartisan agency. We've been around for a long time, since 1901. And our agency was the model for similar agencies that on the state and federal level. We're involved in a lot of the process, a lot of the legislative process. We draft all the legislation. We just finished drafting the executive budget bill, draft amendments, analyses of legislation. We do research on history, policy, on other legislation from other states. And we also publish a wide variety of things such as the statutes, the administrative code, the Blue Book, of course, and a lot of research publications. Today, I want to focus on one in particular. We have put out the LRB Guidebook, Redistricting Wisconsin 2020, that Mike and Stacy and I all worked on. A lot of the information that we're giving out today will be in the guidebook, including a fairly extensive history of redistricting in the state, in addition to all the considerations, legal and practical. So having covered that, I'm going to move fairly quickly so that Mike can get into his presentation. The first thing we need to talk about is the terminology we're using. The terms reapportionment and redistricting are frequently used to mean kind of the same thing, interchangeably, but technically they're very different things. Reapportionment refers to the reallocation of seats in the House of Representatives, which happens every 10 years after the census, whereas redistricting, on the other hand, is drawing our lines on the legislative districts and local districts based on shifts in population. Just to make sure we have proper representation of all potential voters in any given geographic area. So why do we redistrict in the first place? It's probably obvious, but I'll state the obvious. The US Constitution requires that we reapportion congressional seats every 10 years. Specifically, you're looking at Article 1, Section 2, Clause 3 of the US Constitution that provides that the actual enumeration, in other words, the census, shall be made within 3 years after the meeting of the Congress. So that has happened long ago. And now within every subsequent term of 10 years in such manner as they shall direct by law. Often referred to as the census clause or the enumeration clause, this mandates an actual enumeration, a complete count, every 10 years of every resident in every household in the United States. There are federal constitutional requirements that we have to comply with. The 14th Amendment provides that representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state. We also have Title 13 of the US Code. Congress has delegated the administration of the census to the Census Bureau. So with these two constitutional provisions, the enumeration clause and the 14th Amendment and Title 13 of the US Code, we do have to have a complete count of the United States population every 10 years. First of all, to reapportion the 435 seats of the House according to population changes. And the federal decennial census kicks off the whole process. So depending on population shifts, as determined by the census, some states will gain congressional seats, some will lose, and many will stay the same, which is what we anticipate will happen with Wisconsin. We'll retain the same number of representatives in the House. So after reapportionment, each state must redraw congressional, legislative, and local district lines according to requirements laid out in the state constitution and state statutes. In Wisconsin, we have Section 3 of Article 4 of the Wisconsin Constitution, which gives the state legislature the power to redraw both congressional and legislative district boundaries. Although it's not explicit in the language of Section 3, the Wisconsin Supreme Court has ruled that a plan must be enacted the same way you enact any law. So in other words, a bill is introduced, or perhaps several bills are introduced, all of which the LRB drafts. That goes to both houses of the legislature. If it passed both houses, it goes to the governor, who can approve it or who can veto it. And like any bill, the governor's veto may be overridden by the legislature by a 2/3 vote in both houses. This process presents a fairly considerable obstacle to get around. So it's no surprise that over the years, a lot of our redistricting plans, not only in this state, but in other states, have been drawn by the courts. 2011 in the state of Wisconsin was a notable exception. You had unified control of both houses and the governor's office. And so those obstacles that I just mentioned were not there. So now we kind of know why redistricting must occur. We'll discuss federal and state requirements at this point. Like all states, Wisconsin congressional, state, legislative, and local electoral districts must comply with 2 federal requirements: equal population and minority protection. Equal population is the underpinning of the whole process. I won't get into too much detail about some of these terms, but for ideal population, we'll go right to that one. The concept of ideal population is basically determining the target population for each district in a redistricting plan. So your ideal population is calculated by dividing the total population of the unit you're going to divide into districts by the number of districts being created. To give you an example, using kind of a whole number, if you have 5 million people in 50 legislative districts, your ideal population is 100,000. So just a brief example of how that would look: if your estimated total population in Wisconsin is 5,854,594, and that is our estimate from January 1st, 2020, but it's not the census data. If we were to redistrict using that number, we'd have a Senate population of 177,412 and an Assembly district with a population of 59,137. Again, this is only for purposes of illustrating what we're doing. We wouldn't be using an estimate. We'd be using the census data when we finally get it. That in itself is an estimate, but that's the official estimate. There are other terms that we use, and I'm not going to go into great detail as far as determining your population, but really the biggest consideration is the overall range. And Ryan mentioned this as far as how far you're able to deviate. Overall range is used to assess equality of population of a plan as a whole. So your overall range is the difference in population between the smallest and largest districts in a redistricting plan. And overall range is used to evaluate that plan as a whole, either at the state level or the local level, the county or municipal level. And that number is used to evaluate population equality. We are allowed some deviation when it comes to state and local redistricting. As this quote says, we're permitted to deviate somewhat from perfect population equality to accommodate traditional districting objectives like preserving integrity of political subdivisions, maintaining communities of interest, and creating geographic compactness. And I'll talk more about those shortly. But if you can get a deviation that is less than 10%, that's presumed to comply with one person, one vote, which is the standard we're looking at based on the 14th Amendment and Supreme Court jurisprudence. So again, if we use that 100,000 as an ideal population, just to get a nice round number, if we assume the largest district in a redistricting plan has a population of 101,000, 100,000 people, and the smallest district has a population of 98,000 people, your overall range is going to be 3%. We get that basically by looking at if your deviation in the large district is plus 1,000 and the deviation in the smallest is minus 2,000, we put those together, but we ignore the plus and minus, and we end up with 3,000 people or 3%. So like I said, even though we have with modern technology and statistical methodology, it would seem that we could get better than 10%, and we actually do get better than 10%. But we do have competing interests, which I'll talk about in a second. I do have to back up a little bit. The standard is somewhat different, quite a bit different actually, for congressional districts. The courts have found that equal population in congressional districts, it's nearly equal in population as practicable. It's strict population equality. So the lowest possible deviation from ideal population in each district has to be pretty close to spot on. No level of population inequality is deemed too small for judicial review. The state has actually did a pretty good job of hitting overall range targets for state legislative districts. All you have to show is substantial equality of population. So again, we're talking about an overall range of less than 10% of the ideal population. And that also applies to the local electoral districts. Wisconsin has historically achieved a much stricter population deviation standard for its state legislative districts. The overall range has been as little as 0.76 for the 2011 maps, but definitely less than 2% going all the way back to 1982. So besides population equality, the other important consideration is protection of minorities. In 1965, Congress enacted the Voting Rights Act to order to remedy this inequality of opportunity provided to racial and ethnic minorities and give them a better chance to participate, meaningful participation in elections. Section 2 of the Voting Rights Act prohibits any state or political subdivision from imposing a voting qualification prerequisite, standard practice or procedure to deny or abridge the right to vote based on race or color. In 1975, they expanded these protections to include language minority groups. And in 1982, they made the act apply not only to intentional discrimination, but also to plans that have the effect of discriminating, even if that was unintentional. In practice, at the most basic level, a redistricting plan may be challenged if it splits up a racial or language minority group and combines its members with a majority group, effectively limiting the ability of that minority group to elect a candidate of its choice. This is known as vote dilution. A redistricting plan in which the voting strength of a minority is diluted is most often challenged because the plan violates either the Equal Protection Clause of the 14th Amendment or the Voting Rights Act of 1965, and sometimes it's challenged based on both. So other than the required federal principles of equal protection and minority protection, states impose additional requirements, and Ryan touched on this somewhat in his presentation. These are referred to as traditional redistricting principles. They have come about either naturally through how the states have redistricted over the years, through state constitutions, through other legal cases, both state, local, and federal. But these are generally the four that show on the slide: compactness, contiguity, preserving communities of interest, and preserving the unity of political subdivisions. So I'll touch on each of these briefly. Again, Ryan talked about compactness. The image in blue is obviously more compact, I think it's obvious, than the other image, which is not so compact. And again, depends on your your instrument of measurement, but in either case, the blue district is more compact. So that represents the general principle. Contiguity is the general principle that each area within a district should be physically adjacent to another area that is also within this district. The major exception for us is island territory, and Mike will talk about that. So again, if you look at the one slide compared to the other, the one on my left is contiguous, the one on my right is not. I will assume that's island territory, but it's definitely not contiguous. Respecting communities of interest in redistricting plans means attempting to group like-minded or similar people together so that they can elect representative of their choice that reflects kind of their common background or their common interest. And this is different than a community of interest viewed for purposes of protecting minorities. This can be as much as, do we have a cohesive group, neighborhood in a municipality that it has an identity all its own and it's well known. Those are some things you would think about when trying to pinpoint a community of interest. Respecting the unity of political subdivisions is next, which pretty clearly means avoiding having to cross county, city, or town boundaries when drawing district lines. Again, there are exceptions. The map on the left respects the county lines. On the map on the right shows district lines that intersect the boundaries of a number of counties. It may be more pleasing to the eye, the wavy line there, but it definitely would not be keeping together political subdivisions. And sometimes it's not, and you may know better than I how hard it is sometimes to keep communities together on the ground when trying to redraw lines. So in addition to the federal requirements of equal population and minority protection, Article 4 of the Wisconsin Constitution governs the basic requirements for state legislative redistricting. While there's no specific date by which state legislative redistricting must be completed, we have a deadline of sorts for the state legislature to adopt a legislative plan under Article 4, Section 3 of the Wisconsin Constitution. Section 3 provides that the legislature shall apportion anew the members of the Senate and Assembly at its first session after the federal decennial census. So the next round of redistricting will take place during this session whenever we finally get the data and once all the local line drawing is complete. At least that's the plan. So this session ends on January 2nd, 2023, but the real target date that the legislature hopes for is to hit the 2022 election, and we'll see if we meet that. Wisconsin typically enacts congressional district maps at or before the time state legislative maps are enacted. Historically, our congressional district line drawing has not been as controversial as the legislative districts. Typically, that process has been much quicker and much less contentious. Section 4 requires assembly districts to be bounded by county, precinct, town, or ward lines to consist of contiguous territory and to be in as compact a form as practicable. And that's an example of your traditional redistricting principles being laid out specifically in the state constitution. Section 5 requires state Senate districts to be of convenient contiguous territory. And again, another reiteration of traditional redistricting principles. As I mentioned earlier, once a plan is drafted by the legislature, it's treated like any other bill. It must be passed by both houses and approved by the governor before it becomes law. And if the process doesn't work that way, as you know, it will end up being figured out in the courts. So I think I've covered the basics. I skipped over some of the minutia just to give Mike some more time to talk about the local redistricting law and the process in the state of Wisconsin. So go ahead, Mike.
Okay, there I am. Am I coming through? My my grid disappeared from the screen for a moment. Okay, so thanks, Joe. Yeah, and as Joe said, I'm also a legislative drafting attorney with the with LRB, and we split things into subject areas here, and so I'm drafting in elections now. Joe's been doing it a little bit longer than I have. I've been with LRB for 10 years, but I wasn't directly involved in the redistricting process in 2011. So this is all kind of new to me, and I think it's going to be, even if you were participating last time around, that was a different process than you would have been used to in the past, and now this redistricting cycle is going to be totally new as well, because as I'll talk about at the end of the presentation, the redistricting data is anticipated to be delayed until perhaps the end of September. So that will affect, obviously, the local redistricting process, because it can't begin until we have that data. So just to begin, just as with congressional and state legislative redistricting plans, the federal requirements of equal population and minority protection apply in the local redistricting context as well. So with respect to equal population, as Joe said, the one person, one vote requirement that's embedded in the 14th Amendment to the US Constitution means that local electoral districts must be substantially equal in population. And so, yeah, Joe, as Joe mentioned, we spared you the minutia with respect to calculating equal population. There are a number of specific terms you may be familiar with: ideal population, relative deviation, absolute deviation, et cetera. Overall range is the one we focus on, which basically is the measure between a measure of the difference between the largest district in a redistricting plan and the smallest district in a redistricting plan. And so if you have a 10% deviation between those two, then or less, then the Supreme Court has said for local redistricting plans, you're presumed to satisfy the equal population requirements of the Constitution. If you go above 10%, it could still be upheld by a court if it were challenged, but you lose the benefit of that presumption. And if it's under 10%, it is only a presumption. And although the U.S. Supreme Court has said that it's unlikely that if you're under 10% and you're talking about local districts, that there's going to be a successful challenge on equal population grounds, but it is possible. Okay, so, and if you're really into mind-numbing, detail and calculations and measures and criteria, then not to make it sound so attractive, but all of the formulas that are used for calculating equal population are in the LRB redistricting guidebook. But lucky for you, the nifty WiseLR software that LTSB has developed just does the calculations for you right there behind the scenes. So anyways, all right. And also the ban on racial gerrymandering, the requirements of the Voting Rights Act of 1965 also apply in the local redistricting context. But I'm not going to go into detail on those. And again, if you want to read more about that, I'd recommend looking at the LRB guidebook, because it covers it all in great detail. Okay. So with respect to the process itself, in Wisconsin, redistricting, as Ryan indicated, occurs in 3 phases essentially. And it requires the cooperation and coordination among counties and respective municipalities. It's really a collaborative process. It's a process that starts at the county level in phase 1, with the counties adopting tentative supervised redistricting plans. And then in phase 2, it moves to the municipalities adopting ward plans, and then finally in phase 3, counties adopt final supervised redistricting plans, and the municipalities adjust aldermanic districts, at least in municipalities that don't elect their alders at large. And so each phase has a 60-day work period. But as Ryan mentioned, for example, in the first phase, if You don't have to take 60 days to do your tentative plans. If you do it in 16 days or some other variation, then the clock starts ticking then once the plan is adopted by the county board for the municipalities to adopt their new ward boundaries. And so same thing, obviously, with the final phase. It begins for the county when all of the municipalities in the county have completed their ward plans. So I'll talk about each one of these phases in a little bit of detail. Like I said, the receiving census data kicks off the whole process. Last redistricting cycle, we received the official data was published on March 10th, 2011. That's not going to happen. We recently have learned from the Census Bureau that it may not even arrive until the end of September. And I'll talk about the potential impact of that at the end of the presentation. Okay, so moving on to phase one, within 60 days after the official publication, and I should say this, so you can see on the slide that the statutes have a drop dead date, of July 1 of the year following the year of the census for counties to adopt tentative supervisory district plans. But obviously, if we don't receive data until the end of September, then the counties are not going to meet that deadline through no fault of their own. And so really we're looking at the whole process starting based on the publication of the data and looking at that 60-day period. I'll talk a little bit about what the county board's responsibilities are in adopting a supervisory tentative plan. First, they have to solicit suggestions from municipalities concerning the development of an appropriate plan. Again, like I said, and as Ryan indicated a number of times, it's really a collaborative process between the county and the municipalities. The county must hold a public hearing. The county must submit a copy of the proposed plan to each municipal governing body in the county. And in the event that a municipality needs to be divided between 2 or more supervisory districts that can't be accommodated within the existing ward plan, county board has to submit a written statement to the municipality indicating the approximate location and population of proposed wards. And I'll talk about the municipality's obligations in that regard in a bit. So with respect to the plan itself, it must establish the number of districts, which must be equal to the number of supervisors. And the statutes in section 5910 of the statutes, 59.10, set forth the ranges for populations and associated numbers of supervisors. There's also a table in the LRB guidebook that provides that, as well as other tables that provide some of the other information that's in the statutes, but that is more easily consumed in a graphic way. Okay. Districts have to be substantially equal in population. Again, applying that 10% threshold that we talked about before. The districts must generally consist of whole wards or municipalities. The territory within each district must be contiguous. As Joe said, except for island territory in the statutes is defined by territory, obviously, that is surrounded by water, or territory of a municipality, or territory that's, and this applies more later, but territory that's surrounded by the territory of another municipality. All right, and so after receiving the tentative supervisory district plan, municipalities have 60 days to adjust their ward boundaries. And that's phase 2. But before we get into it in detail, I'll just cover some basics on wards. Wards play a central role in the redistricting process in Wisconsin because they're the building blocks from which congressional, state senate, and assembly districts, county supervisory and aldermanic districts are all constructed. Ward boundaries are intended to be as permanent as possible, with changes made to, obviously, to accommodate changes in population, alteration in municipal boundaries, and in order to try to accommodate the mathematical requirements of creating electoral districts of equal population for purposes of one person, one vote. The statutes require all cities, villages, and towns in Wisconsin with a population of 1,000 or more to divide into wards. Municipalities under 1,000 don't have to divide into wards, but they can do so in order to facilitate the administration of elections, and also it may be necessary to accommodate county supervisory districts of equal population. The governing body of the municipality is responsible for establishing ward boundaries. Okay. So in terms of the basic rules governing the creation of wards, wards must be comprised of whole census blocks, but there are a number of exceptions, and I'll only just mention one. If a census block is split by an annexation or detachment that has occurred since census day, then the block must be split, and only the territory within the municipality contained within the block must be contained in that ward. So to suit the convenience of voters, wards should be compact, observe communities of interest, as Joe talked about, which can mean many different things. They have to be comprised of contiguous territory. Again, island territory is an exception. If you have a municipality that, if you have a part of a municipality that is surrounded by another municipality, and so is separated off from the major part of the municipality, that's considered island territory also. And if you want an example of that, you know, Joe's better at giving those examples. There are some in Madison, for example. Comply with the population ranges specified by law, and I'll talk about that in a minute. So, and I'll just note that wards are not electoral districts. They're not, so they don't have to be of equal population. You know, they're not districts from which public officials are elected in the sense of the requirements of one person, one vote. And so we have specific population ranges. Wards are used, they're administrative subunits that are used to construct equal population districts, but they're not equal population districts themselves. We'll talk a little bit more about that. Lie entirely within one municipality and one county. They can't cross municipal and county lines, and then be designated by consecutive unique whole numbers beginning with number 1. Okay, so these are the population ranges for wards. Wards can be established below the statutory population ranges for a number of reasons. And the statutes further direct that the population of a ward should be established at a convenient level within the prescribed population range due to consideration for the known trends of population increase and decrease. Accordingly, the population of each ward should be set at a level that satisfies the applicable population range, but because wards are intended to be as permanent as possible, that can accommodate fluctuations in population over a relatively long period of time. All right, so adjusting ward boundaries. Like I said, they're intended to be as permanent as possible, but after the federal decennial census, they may have to be adjusted for a number of reasons, and I'll just run through these fairly quickly. Number 1, obviously reflect changes in population since the last federal decennial census. Okay, if they no longer fit within the statutory range. Reflect changes in minority population. And so Joe mentioned the Voting Rights Act of 1965, and in our statutes, there's actually language that virtually mirrors that act that applies to wards. The statutes say that ward boundaries must have to be adjusted, or may have to be adjusted, to enhance the participation of members of racial or language minority groups in the political process and their ability to elect representatives of their choice. And that really is quite close to the language of the Voting Rights Act. So although they're not electoral districts, in building wards, municipalities need to take into account racial and ethnic and language minority groups, so so that they can be the wards can be combined in such a way that that the Voting Rights Act requirement of enhancing, the participation of minorities in the electoral process can be satisfied. Okay. Reflect changes in municipal boundaries since, the last census. Facilitate the establishment of county supervisory districts. The statutes say that the municipality has to make a good faith effort to accommodate the county's proposed supervisory district plan. And the basic idea is what we're trying to do is accommodate the county's construction of supervisory districts of equal population. That's really what is driving the reconciliation process that Ryan talked about. That happens in phase 3, but here there's communication, collaboration in establishing a ward plan, trying to accommodate county supervisory districts of equal population. Okay. And also, with respect to aldermanic districts, which also have to be of substantially equal population, ward boundaries may have to be adjusted in order to do that. And then finally, and I'm not going to talk too much about this, but accommodate a legislative redistricting plan. Anyone, if you participated in redistricting in 2011, then you're painfully aware that the legislature acted extremely quickly and passed congressional and legislative redistricting plans before ward boundaries were created. And what the legislature did was pass an act that was signed by Governor Walker that facilitated that happening. And then municipalities had to adjust their ward boundaries based on plans that were put forth by the legislature. That essentially reverse process. Typically, the ward plans are done, and that's what the legislature uses to build legislative and congressional redistricting plans. And that's most likely what's going to happen this time around. Just as a political reality, in the there may be some complication with respect to the data arriving late and the legislature perhaps moving quickly to try to accommodate the 2022 general election cycle or schedule. But I would say, don't quote me on this, but I would say it's highly unlikely that Act 39 is going to happen again. It's most likely that the local redistricting process will work its way through, and then state legislative and congressional redistricting plans will be put in place. But like I said, I know this is being recorded, but don't quote me on it. All right. So let's see. Okay, and then phase 3, just quickly, the counties have to hold another public hearing and adopt final supervisory redistricting plans, and cities not electing their common councils at large would then adopt their aldermanic districts. And again, that has to be done within 60 days after the municipalities or the city's wards are after the ward plan is adopted. Okay. So this is the default timeline. You can look at it and admire it, but it's not going to come to pass. The Census Bureau recently told us that we are not likely to get official census data for purposes of redistricting until the end of September. So you can see from this that typically then the entire local redistricting process would be completed no later than the end of September. So what does that mean? Well, if we look at the 2022 election timeline, and we're looking here at the spring primary and spring election, nomination papers would have to be circulated for the spring primary by December 1, 2021. Okay, if we get redistricting data at the end of September, then almost certainly we're not going to have new plans in place by that December 1, 2021 circulation date. And if that happens, then essentially the spring primary and election in 2022 would take place under the old maps. And same thing for the legislature or for legislative and congressional redistricting, whether it's the legislature and the governor working together, or if that doesn't happen and the courts put maps in place, again, if they're not in place by that April 15th nomination papers may be circulated date, then those also would be the election, the general election would happen under the existing maps, the current maps. So that's really, the effect. It's just a question of when the new maps will actually take effect, if they're running up against that 2022 election timeline. All right, so I think that covers it. We had to go through this a little more quickly because we only had until 2:30, but I will go ahead and stop sharing my screen.
We do have one question in the chat, and
Excellent.
we have a little time, so let's do it. It
Okay.
says, is there any legislation or push for legislation for parcel-based districting? We have numerous parcels that have school district lines running through them, and it makes for a headache.
Parcels with school district lines?
Yeah.
Joe, okay, go ahead.
Well, yeah, I think, yeah, so you're trying to create a ward, right? And you have like, you're up against like two different school districts are running through where you want to put a ward. Of course, that creates headaches for the clerk and for running an election. And we get that a lot. However, to answer your question, no, there's no push to deal with that. And nor do I ever recall there being a push to deal with that. I don't know what else to say about that. And I know it's a complicating factor, but the farther down you dig trying to create lines, the harder it becomes to make this all work together. And honestly, at a macro level, it just doesn't come into play. But yes, it does create headaches.
Yeah, and yeah, unfortunately, yeah, school districts are just not something that is formally taken into account in redistricting, but they are things that can be considered when you're thinking about communities of interest and how lines are drawn on the ground with respect to that.
Great.
I do recall when it came up in a couple other presentations that DPI seems to be trying to make an effort to eliminate some of the more some of the worst problems. I'm not sure how successful they are in doing that, but it seems like that's at least something on their radar that they're looking into. So.
Yes, they have greatly improved their boundary understanding, and I know that LTSB has that incorporated in the WISE-LR system, so it can be used as a reference. Well, thank you both so much. Great presentation, Michael and Joe Cry.